Judgment in the matter of Commissioners for Her Majesty's Revenue and Customs versus Frank A. Smart and Son Limited, Scotland.
Lord Hodge will explain the decision of the court.
This appeal concerns a claim by a farming company to deduct or receive repayment of value-added tax. The claim arises from a rather enterprising arrangement which Mr. Frank Smart implemented through his farming company, Frank A. Smart and Son Limited, which I will refer to as FASL. For several years, until about 2014, the European Union paid subsidies to farmers, not for the production of food or other farm produce, but for keeping their land in good agricultural condition. Farmers were allocated units of entitlements to the subsidy, which was known as single farm payments, according to the number of hectares of eligible land which they held. These units of entitlement, which I will call SFPEs, single farm payment entitlements, could be bought or sold, and a market for them was developed. FASL was allocated 194.98 SFPEs for the farmland which it farmed, but it purchased another 34,377 units for £7.7 million by borrowing money from a bank, and then entered into arrangements with other landowners to lease, but not to farm, over 35,000 hectares of land. The land was leased for very low rents, and the arrangements were generally that the landlord could use that land for its own purposes as long as the land was kept in good agricultural condition to allow FASL to qualify for the subsidy. Between 2010 and 2013, FASL received SFP subsidies amounting to in excess of £8.6 million, which it used to repay its borrowings and kept the surplus to invest in its business. Under the system of VAT which applies throughout the European Union, tax is in principle charged on the ultimate consumer of goods and services. As a result, a trader who charges VAT on his goods and services to that consumer accounts to the revenue for the tax received and is entitled to deduct from what he or she pays to the revenue the VAT which he or she has already paid when purchasing goods or services to create the product which has been sold to the ultimate consumer. In other words, the payment to the revenue which the trader has to make in respect of output VAT received from the ultimate consumer is reduced by the deduction from that sum of the input VAT which he or she has paid. In this case, FASL paid VAT on the purchase of the SFPE units. It sought to deduct from its output VAT for its farming business this input VAT and to claim repayment of the surplus input VAT from HMRC. The VAT in question amounted to over £1 million. When HMRC refused to allow the deduction, FASL successfully appealed to the First-tier Tribunal, which upheld its appeal. The tribunal held that FASL, when it purchased the units, intended to use the money which they would generate to pay off its overdraft and to develop its farming business, for example, by developing a wind farm, building further farm buildings, or purchasing neighbouring agricultural land. It held that the funding exercise which the purchase of the SFPE units involved was not a separate business activity, but was, in its words, a wholly integrated feature of the farming enterprise. HMRC's appeals to the Upper Tribunal and the Inner House of the Court of Session in Scotland were dismissed. HMRC now appeals to this court. In a unanimous judgment, this court dismisses the appeal. In the judgment, the court analyses the developed jurisprudence of the Court of Justice of the European Union on the question of the deductibility of VAT paid on goods and services purchased in a fundraising exercise. In paragraph 67 of the judgment, the court sets out 7 propositions which are derived from that analysis, and I will not weary those listening to this handown by reading out those propositions. Instead, I will give a brief summary. In short, EU law requires a direct and immediate link between a trader's expenditure on an input transaction and the taxable supplies which it later makes and on which it charges output VAT in order to give rise to this right to deduct the input VAT which it has paid when it accounts to the revenue for VAT. That link can be either because the costs of the input goods or services are cost components of particular output transactions, or because those costs are part of the overhead costs of what is called the taxable person's general economic activity. In other words, its taxable business as a whole. Therefore, if the fundraising activity is itself outside the scope of VAT, a trader can still deduct as input VAT the VAT which it has paid on the services connected to that fundraising if the funds were objectively intended to be used and are later used to develop its business of providing taxable supplies. There may be a time lapse between the deduction of input VAT incurred in the fundraising and the use of the funds so raised in downstream taxable activities, but the question of whether there is the needed link between the two is a question of fact to be determined objectively in the light of the circumstances of the case. On the First-tier Tribunal's assessment of the facts, which I have summarised, it was entitled to conclude that there was such a link between the purchase of the SFPE units and FASL's present and future taxable activities. This court, therefore, dismisses the appeal.
Thank you.